The origin of emergency arbitration provisions in international arbitration rules is relatively recent. These provisions emerged to address the evolving needs of international commerce and the limitations of traditional arbitral procedures in urgent situations. Historically, arbitration faced criticism for its inability to provide immediate relief in urgent situations. Parties had to turn to national courts for interim measures, which could be time-consuming and costly. As international arbitration became the preferred method for resolving cross-border disputes, the need for a mechanism to address urgent interim relief became more pronounced. Arbitration institutions began to explore ways to provide interim measures within the framework of arbitration itself. The International Center for Dispute Resolution, ICDR, was one of the first to introduce emergency arbitration provisions in 2006. The Singapore International Arbitration Center, SIACI, followed in 2010, refining the process. The International Chamber of Commerce, ICC, introduced its provisions in 2012, marking a significant moment in the broader acceptance of emergency arbitration. Following these pioneers, many other leading arbitration institutions incorporated similar provisions into their rules. The rise of global commerce and the need for quick, enforceable solutions drove the widespread adoption of these provisions. Emergency arbitration has become a standard feature of most major arbitration rules, providing urgent, interim relief before the main tribunal is constituted. Businesses involved in international trade often require swift solutions to prevent irreparable harm. Some jurisdictions have amended their arbitration laws to recognize and enforce the decisions of emergency arbitrators. Despite advances, enforceability remains inconsistent across jurisdictions. In Nepal, while still evolving, this concept is gaining traction in international arbitration cases. Emergency arbitration provisions have rapidly gained acceptance, becoming a vital tool in modern arbitration. They reflect the arbitration community's commitment to providing comprehensive and effective dispute resolution mechanisms. So next time you're in a crunch, remember, emergency arbitration is the legal ace up your sleeve. While emergency arbitration provisions offer significant advantages, they also have some weaknesses and limitations that can affect their effectiveness in practice. Here are some of the key weaknesses. 1. Not all countries recognize or enforce emergency arbitration decisions as they would final arbitral awards. This can limit the practical effectiveness of emergency arbitration in certain legal systems. The success of enforcing an emergency arbitrator's decision often depends on the willingness of national courts to recognize and enforce such orders. In jurisdictions where courts are reluctant to enforce these decisions, the relief granted may be ineffective. 1. Meant to last only until the main tribunal is constituted. This can be a limitation if the need for interim measures extends beyond the period before the tribunal is formed, requiring further applications to the main tribunal. The types of interim relief that an emergency arbitrator can grant may be limited, particularly if the emergency arbitrator is cautious about exceeding their mandate. This can result in insufficient protection for the parties seeking relief. 1. Including the fees of the emergency arbitrator and the administrative costs charged by the arbitral institution. For parties already engaged in an expensive arbitration process, this can represent a substantial financial burden. The high costs associated with emergency arbitration might disproportionately impact smaller or financially weaker parties, potentially deterring them from seeking emergency relief even when it is warranted. 1. Such as filing for emergency measures primarily to delay proceedings or to exert pressure on the opposing party. This could lead to an unnecessary increase in the complexity and cost of the arbitration process. In some cases, parties may exaggerate the urgency of their situation to obtain favorable interim relief, which might not have been granted under normal circumstances. This can undermine the fairness of the process. 1. This can lead to concerns about whether the process allows sufficient time for a thorough examination of the facts and for both parties to fully present their cases. Due to the time-sensitive nature of emergency arbitration, there may be limited opportunities for hearings or for the presentation of detailed evidence. This could lead to decisions based on incomplete information, potentially compromising the quality of justice. 1. The lack of a robust appeal mechanism can be a weakness. If a party believes that the emergency arbitrator's decision was flawed, there are often limited avenues for immediate redress. Given the lack of appeal options, a hasty or incorrect decision by an emergency arbitrator could have significant adverse effects, especially if it disrupts the status quo or causes harm that cannot easily be undone. 1. Including timelines, types of relief available, and procedures. This lack of standardization can create confusion and uncertainty, especially in cases involving parties from different jurisdictions with different expectations. Some arbitration agreements may explicitly exclude emergency arbitration provisions, either due to the party's preference or due to institutional rules. This can render the emergency arbitration mechanism unavailable when it might otherwise have been useful. 1. Emergency arbitration might be less effective. The emergency arbitrator's ability to issue enforceable orders across different jurisdictions can be limited, particularly if those jurisdictions have different legal standards, or if the parties have assets in countries that do not recognize emergency arbitration orders. The logistics of quickly appointing an emergency arbitrator, especially in cases involving parties in different time zones or with complex dispute details, can pose practical challenges that may delay the process. Emergency arbitration provisions, while valuable in providing swift interim relief, are not without weaknesses. Issues related to enforceability, costs, potential for abuse, and the balance between speed and due process can limit the effectiveness of emergency arbitration. Understanding these weaknesses is essential for parties considering the use of emergency arbitration, and they should weigh these factors carefully when drafting arbitration agreements or deciding whether to invoke emergency arbitration provisions. Nepal, like many other countries, is gradually integrating international arbitration practices into its legal framework. However, the concept of emergency arbitration is still relatively new in Nepal. Here's an overview of the status and development of emergency arbitration provisions in Nepal. Firstly, let's look at the primary legislation governing arbitration in Nepal is This act outlines the procedures for conducting arbitration, the powers of arbitral tribunals, and the enforcement of arbitral awards. However, the act does not specifically address the concept of emergency arbitration. As of now, the Arbitration Act of Nepal does not include explicit provisions for emergency arbitration. This means that if parties require urgent interim relief before the formation of an arbitral tribunal, they may need to seek such relief through the national courts. Next, we have, under the current legal framework, parties involved in arbitration in Nepal can approach the courts for interim measures of protection. This is similar to the practice in many jurisdictions before the introduction of emergency arbitration provisions in institutional rules. The courts in Nepal are generally supportive of arbitration and have the authority to grant interim measures to safeguard the interests of the parties pending the resolution of the dispute through arbitration. This could include orders to preserve assets, prevent the disposal of property, or maintain the status quo. Moving on to. Although Nepalese law does not yet provide for emergency arbitration, parties to arbitration agreements in Nepal can choose to apply institutional rules that include emergency arbitration provisions. For example, if parties agree to arbitrate under the rules of the International Chamber of Commerce, ICC, Singapore International Arbitration Center, SIAC, or any other institution with emergency arbitration provisions, those rules would apply. There is a growing awareness among legal practitioners and businesses in Nepal about the benefits of emergency arbitration. As international commercial activities involving Nepalese entities increase, there may be greater adoption of institutional arbitration rules that provide for emergency relief. Now let's explore There is potential for the modernization of Nepal's arbitration laws to include provisions for emergency arbitration. As the arbitration landscape evolves globally and in the region, Nepal might consider updating its Arbitration Act or introducing new regulations to align with international standards. As more Nepalese businesses engage in international trade and investment, the demand for mechanisms like emergency arbitration is likely to increase. This could drive legal reforms and the adoption of more sophisticated arbitration practices in the country. Finally, we must consider for emergency arbitration to be effectively integrated into Nepal's legal system, it would require the judiciary and legal practitioners to be well versed in the concept and practice of emergency arbitration. Training and capacity building efforts would be necessary to ensure that emergency arbitration orders are understood and enforced properly. Additionally, as Nepal moves towards embracing international arbitration practices, there will be a need to balance these with the existing legal traditions and practices in the country. This could include considering how emergency arbitration provisions align with the broader legal and judicial framework in Nepal. In conclusion, emergency arbitration provisions are not yet explicitly incorporated into Nepal's domestic arbitration law. However, parties in Nepal can access emergency arbitration through the adoption of international institutional rules that include such provisions. As Nepal continues to develop its arbitration framework, and as international commercial activities grow, there may be opportunities for the integration of emergency arbitration provisions into national law, enhancing the effectiveness and attractiveness of arbitration in Nepal.